Over the past decade, there has been a dramatic increase in the number of rental properties in Arizona. At least once a week, I am contacted by a board regarding problems with a difficult tenant not following the association's documents. In this presentation, I'll give you the 411 on Arizona law regarding rental properties and how to effectively work with rental properties in your community. Hello, my name is Beth Mulcahy, and I am the managing partner and senior attorney of the Mulcahy Law Firm in Phoenix, Arizona. Mulcahy Law Firm represents thousands of planned communities and condominium associations throughout the state of Arizona. How to effectively handle rental properties in a condo or planned community. Owners have the right to rent their property in a planned community or a condominium, unless rentals are prohibited in the CC&Rs. However, associations can have rental time restrictions in the declaration. Associations can only ask for the following information regarding rental properties: the name and contact information for any adults occupying the unit, the time period of the lease, including the beginning and ending dates of the tenancy, and a description and license plate numbers of the tenant's vehicles. If the association is an age-restricted community, the owner, owner's agent, or tenant must provide the association or its manager with government-issued identification with a photograph of the tenant and confirmation that the tenant meets the association's minimum age restriction. The association may charge the owner a rental fee of not more than $25 to be paid within 15 days after a postmark request from the association. The association or its manager cannot assess, levy, or charge a fee or fine or otherwise impose any requirements on an owner's rental unit that are any different from an owner-occupied unit in the association. For example, under this section, it would not be appropriate to charge a tenant a parking fee if such a fee is not charged to owners who occupy their unit or lot. The association can charge a fee of $15 if the landlord-owner fails to provide this information, doesn't provide complete information, or provides the information in an untimely manner. It's important to note that Arizona law doesn't allow an association to do the following: requiring an owner to provide the association with a copy of the tenant's rental application, credit report, lease agreement, or rental contract, or any other personal information, except as permitted. Here are the answers to the most commonly asked questions about rentals in a community association. Can tenants attend board meetings and/or be designated by the owner as the owner's representative? Typically, tenants are not allowed to attend board meetings. There is an exception. Tenants may only attend board meetings if the board voluntarily allows them to do it, or if the owner designates the tenant in writing as his or her representative. Can a tenant be elected to the board? In most instances, the bylaws restrict the board to members of the association. However, if the bylaws do not require that board members be members of the association, then non-members, which includes tenants, can serve on the board of directors. Can tenants vote on association issues? No. Only property owners in the association are allowed to vote. How can the association get tenants to comply with an association's documents? Some suggestions would be to contact the owner first in writing concerning the violations. The next step, if the violations don't end, is to fine the owner. Remember, the best way to get a tenant to comply with your documents is to make it hurt in the pocketbook of the owner. If fines are unsuccessful, the next step would be to turn the file over to our law firm for legal action. The first thing we'll do is call the owner and write the owner a demand letter. We'll explain that the matter is escalating and now the owner is responsible for all attorney's fees due to the tenant's violations. This usually resolves the problem. However, in some limited cases, we have to go to our last resort, which is to file a lawsuit against the owner seeking an injunction compelling compliance with the documents or possible removal of the tenant by the court. What can an association do if a tenant is engaging in criminal behavior on the association's property? First, document the tenant's illegal behavior. Contact the police. An owner of a rental property in a condominium or planned community is required to abate criminal activity in the unit or lot under Arizona law. Any residential property that is used in the commission of a crime is a nuisance. Our firm has seen owners be prosecuted by the Maricopa County Attorney under this law. Are there any requirements to register a rental property in Arizona? Pursuant to Arizona law, an owner of a residential rental property must file a notification form with the county where the rental property is located. Owners who fail to comply with this, after notification and a 10-day grace period, are subject to a civil penalty of $1,000 plus $100 per month for every month the owner fails to comply with this requirement. Boards can check to see if a property is registered as a rental property by going to the Maricopa County Assessor's website and typing in the property address of the rental. If a property is not listed as a rental property, contact Mulcahy Law Firm, and we can turn the owner in for violating this law. To obtain a copy of our law firm's cheat sheet on how to effectively work with rental properties, please visit our website at mulcahylawfirm.com or contact our office at 602-241-1093, and we'd be happy to mail or email you a copy of this cheat sheet at no charge. Please contact our office if you need help handling a difficult tenant or any other legal questions pertaining to community association law. Thank you.